Good morning, everyone. We'll go ahead and call the meeting to order. And I think I got that right. Some of them said that I said good morning yesterday afternoon. I don't think I did, but Mayor Greer said I did, so I'll. But we appreciate everyone being here this morning, and we will begin with tab 7, which is Public Chapter 693, and we have, Bob is going to make that presentation, and I think Cliff has a word or two before we get into that.
Thank you, Chairman. I just wanted to set this presentation up a little bit. Bob and the rest of the team has done a lot of really good work on this one. And this is still just a draft report, but as the sponsors of the legislation that sent us the study have already acknowledged, this is one of those studies where we knew it was going to be difficult to get all the information we were looking for. Though we do have a lot of information on tax-exempt publicly held property, largely thanks to our assistance from our state and local partners on the study, and some of whom we heard from at the last meeting. But this is one of those studies where I think one of the biggest wins, some of the best value that comes out of the study is the best practices, where we talk about ways that if the state chooses that decides that there is value in going to some extra effort to gather some additional data, that it could actually set up a lot of potential even better information in the future. And Bob is going to go over the information that we've been able to collect, but then he's also going to go over some recommendations on some of these best practices on ways to improve real estate management in the state and to get even better information on this type of exempt property. So, Bob, thank you.
Thank you, Cliff. Thank you, Chairman. Good morning, Commissioners. Today I will be presenting a draft report for your review and discussion, the result of our study of non-tax producing government-owned property in Tennessee, directed by Public Chapter 693, Acts of 2018, which was introduced by two of our commission members, Representative Mike Carter and Senator Bo Watson, and that draft is behind tab 7 in your books. In July 2016, the city of East Ridge, Tennessee celebrated the grand opening of a Bass Pro Shop store, anchoring a 50-acre retail development, promising to bring jobs and tax revenue to the community. Most of the development sits on property previously owned by the state, under the jurisdiction of the Tennessee Department of Transportation, which had sat unused for many years after the state built a welcome center near the interstate, but had no plans to use the excess land that remained once the project was completed. Developers and city officials sought to acquire the property and put it to productive use, generating revenue from property and sales taxes for the city of East Ridge and Hamilton County. Representative Carter and Senator Watson, familiar with the development, and wanted to know if there were other such opportunities across the state to identify unused publicly held land not being held onto for a specific future purpose. So Public Chapter 693 asked the Commission to determine how much tax-exempt land is owned by the state and local governments, and to research highest and best use recommendations for government-owned properties. And a copy of that legislation is Appendix A in the report. So the first goal of the study was to collect data and attempt to determine how much property the state government owns and find out how it's being used. What we found, and what the report explains, is that there are a few different sources for that information, and that none of them are quite complete and detailed enough to fully analyze how efficiently the state is using its real estate assets, or to be able to state with any certainty how much potential surplus property could be put to better use. A table summarizing all types of government-owned land by total acreage is seen on page 2 of the draft report, and Appendix B, which starts on page 45, has amounts of government-owned property in each county, broken down by federal, state, local, or county and city by type of government. So the total land area of the state of Tennessee is about 26.4 million acres, of which staff determined that about 1.2 million acres, 4.4%, is land owned by the state government. Of course, TWRA and TDAC together account for more than 720,000 acres, about 60% of that total. So a lot of it is forests and natural areas. But for the most part, the state of Tennessee's Real Estate Management Division, STREAM, within the Department of General Services, is the agency responsible for managing an inventory of the state's real estate assets and disposing of unneeded surplus. Its mission is to create and maintain a real estate portfolio that effectively provides for program requirements of the state's agencies while minimizing the total cost of the portfolio. Where the report finds Tennessee's real estate asset management practices falling short is that there's a lack of a requirement for the individual state agencies to report details to STREAM about the current property use and their projected future property needs. STREAM has prepared 2 statewide real estate strategy documents and made efforts to collaborate with each of the state's 23 cabinet and top-level agencies, but it has only been able to get 12 of these agency strategic plans adopted thus far. STREAM staff says the state has made significant progress towards more effective property management. However, additional information from other state agencies on their future real estate needs and current property uses would help them ensure that state-owned properties are being used most efficiently and help them determine which properties may be surplus and could be considered for better use, whether public or private. So the report recommends that Tennessee follow a model set by the federal government and examples from several states to require all state agencies to submit annual real property plans and property use information to STREAM. To make this requirement effective and avoid problems noted by a few states where failure to comply with reporting requirements has no consequences, the report suggests that Tennessee look at what Georgia is currently doing to require agencies submit their real property reports as part of their budget approval process. However, excess transportation right-of-way, like that which was developed in East Ridge, was not included in STREAM's inventory and has not historically been quantified or actively managed by TDOT, which estimates that at the end of state fiscal year 2017, it owned approximately 218,000 acres, valued at about $1.8 billion. This estimate is included in those totals for state-owned land on Table 1 and Appendix B. So TDOT right-of-way makes up about 18% of that state-owned amount. However, most of that is presumably in use and needed for highway purposes with roads sitting on top of it. There's not yet an inventory of excess right-of-way available that would yield an amount of potential surplus property for development. And although TDOT is working to identify excess right-of-way through continued implementation of its integrated right-of-way information systems, they call IRIS, the department says that it lacks dedicated staff resources that it would take to prioritize completion of a comprehensive inventory. The right-of-way division has 1 staff person who can only be dedicated part-time to pursuing excess right-of-way, says it would likely need an additional full-time person to handle this task. So in addition to the recommendation that all agencies submit annual real property plans and property use information to STREAM, the report recommends that TDOT first complete an inventory of all its right-of-way property and determine which properties are needed and which are excess, and in the future, for the department to include that right-of-way property in its annual reports to STREAM. Once TDOT has identified the right-of-way holdings and determined what could be excess, the report does not recommend changes to the statutes governing its disposal, but does recommend that TDOT actively market its surplus right-of-way property for sale, as is done in many other states, and that STREAM and TDOT work together to integrate the surplus right-of-way TDOT properties within the state's overall surplus property strategy for the state. To further ensure the most efficient management of the state's real property assets, stakeholders from STREAM, TDOT, and several other state agencies stress the importance of expanding geographic information systems technology, GIS. We note that the federal government relies on GIS to help it determine the highest and best uses of its property, and other states, including Georgia and Texas, report that GIS provides very useful information for making decisions related to the highest and best use of real estate assets. One describing it as a hugely important tool for property management and invaluable, a critical tool relied upon by internal agency staff as well as external companies and individuals. We find the benefits could be gained across many different government functions, from not only property assessment to facility management, public safety, risk management, and economic development. So the report recommends that Tennessee develop more GIS tools integrated with STREAM's inventory of state-owned property to allow for more robust analysis and help promote the highest and best use of the state's real estate assets. Now, I kind of have a break in here to go between state property and local government property. If you want to take questions and discuss anything related to state property at this time, or just wait till the end, either way is fine with me.
It's all right. We'll just wait to the end and let them ask questions.
Thank you,
so you
Chairman.
can continue.
So attempting to determine the amount of property owned by local governments across Tennessee and see what could be learned about how that property is being used was a significant challenge. Tennessee's 437 city, county, and consolidated local governments do not have a STREAM responsible for maintaining an inventory of their property, nor do we find a reason for there to be one. As shown in Table 1 and Appendix B, local governments only own about 1% of the state's total land area. In most counties, less than 7% of the total county land area is government-owned by any government entity. There are a handful where governments own a third or more of the county, particularly those with large natural areas owned by the federal government. The National Forest Service, for example, controls more than 700,000 acres in Cherokee National Forest, the land between the lakes, and then the National Park Service has another 370,000 acres across the state. So property records were the most logical and widely available source to which to turn for information about what property is owned by local governments. The Controller's Office collects property data from 84 of Tennessee's 95 counties and maintains an integrated database used by several state government entities and by county assessors of property to assess the value of real estate for property tax purposes. Staff collected data from the Tennessee Controller of the Treasury's Division of Property Assessments, the Controller's Office of Local Government, as well as several individual county governments and property assessors. But because this data were originally collected by the Controller's Office and by property assessors for property assessment purposes, they're not intended to serve as a property management inventory and do not always include or rarely include detailed information about property's use and whether it has been or could potentially be declared surplus. The role of the property assessor is to value property for tax purposes, and so we find that accurate records of tax-exempt property owned by governments in particular seem to be given little attention. Staff also looked at accounting requirements issued by the Governmental Accounting Standards Board, GASB, specifically GASB 34 requirements for reporting on capital assets, to see if local governments could use this as a reason to maintain detailed property inventories. However, because these are financial statements only used for accounting purposes, they report capital assets and infrastructure at historical costs in aggregate and do not serve as a detailed property inventory reported at current market or appraised value. The report also notes that while property owned by government entities is exempt from property taxes, the state does make some payments in lieu of taxes, pilots, to local governments to compensate them for loss in revenue when the TWRA and TDEC acquire land for wetland preservation, historic sites, and other natural areas. In fiscal year 2017, TWRA paid $443,000 out to 60 local governments from its Wetland Acquisitions Fund, and TDEC paid $166,000 to 64 local governments from State Lands Acquisitions Fund. To find out more about, because the property assessment data was insufficient, to find out more about how local governments manage their real estate property and their practices, TACIR staff partnered with CTAS and TML to send an online survey to all counties and cities in Tennessee, asking what type and how much property their local governments own, and how they approach the disposal of surplus. Those survey questions and analysis of the responses are included as Appendix C and D at the end of the report. So through the survey responses, follow-up telephone interviews, and testimony at our last commission meeting, we find that local governments report that most of what they consider surplus property has been property they've acquired through delinquent tax sales, and they say which can be difficult to sell because of the time and money needed to establish clear title to attract potential buyers and developers. So the report says that land banks are a tool that can make the process of selling tax delinquent property easier for local governments. Land banks are a special type of quasi-governmental entity created specifically to help communities cope with vacant, abandoned, and tax delinquent properties. They have a statutory authority to establish quiet title and clear challenges to title for properties that they hold, and land banks have been used in some states for more than 20 years to do this. A pilot program, the Tennessee Local Land Bank Program, was created in 2012, limited to the city of Oak Ridge. The General Assembly has since passed legislation extending the authority to establish a land bank to a few other cities and counties that have requested so, but the ability to establish land banks could be further expanded. As the Commission's 2012 report dealing with blight strategies for Tennessee's communities noted, this report suggests that the state can assist local governments with their management of real property by providing legal authority to allow any city or county to establish a land bank. Aside from these challenges local governments have disposing of unwanted property acquired after tax sales, interviews also revealed, and the survey reveals that some local governments feel they have a limited audience to whom they could market any types of surplus property they have. The state laws require governments simply to advertise available property for auction in local newspapers, whether for sale by sealed bid or public auction, and they do allow disposal by online auction as well. But not all local governments have websites where they could advertise their surplus property, but the state does, and the report recommends that the state could help local governments reach a wider audience of potential buyers by allowing local governments to post links to their own surplus properties, including hard-to-sell tax delinquent properties, whatever they've declared surplus, on the state's website where the state advertises its own. Further, the surveys indicated that few local governments would be interested in acquiring more state-owned surplus property, but they feel they might not be fully informed about what potential surplus property the state has in their area. Again, that's an area where GIS capabilities could expand that communication and show everybody where state-owned properties and where local government-owned properties are near each other. The report recommends that the state take a cooperative approach. We found a few states, California, Connecticut, Georgia, Virginia, Washington, where it's required to always notify local government officials of state-owned property available in their jurisdiction before offering the property to the public for sale. Current law says that when something's going to be declared surplus, they notify the legislators from the area where the property is located, and STREAM does go above and beyond and frequently contacts local officials. We just feel it would be good to make it official and have that be best practice of always. So lastly, many of the local government officials we interviewed report that this was sort of a new topic for them, and they don't really have formal planning and management process for their real property. It was really not a topic of concern on a lot of people's radar, but our inquiries have generated some interest as we went through the report. So at the federal level, we find that the GSA offers training for federal employees on topics including real estate laws, asset management strategies, reporting requirements, disposal, and regulations related to environmental and historic preservation compliance to ensure these officials have all the knowledge necessary to effectively manage the federal government's real property assets. In Tennessee, we have University of Tennessee County Technical Assistance Service, CTAS, and the Municipal Technical Advisory Service, MTAS, who conduct research on government best practices and have provided training programs for local government officials in many subject areas for years. Staff has met and discussed things with these two organizations, and our report suggests that the state, through CTAS and MTAS, could develop some training on best practices for real property management for county and city officials to promote the highest and best use of local government-owned surplus property as each local government determines. That's the end of my presentation. I welcome any questions, discussion, and thank you.
Okay, thank you. Questions from members concerning this issue? Yeah, Representative Carter.
No question, just a comment. When we started this, we realized we were trying to unscramble an egg or create cold fusion. And I've read the report, and you all are off to a great start. We didn't expect this to be a one-year project. This is really an elephant to eat. And so we've made the first bite, and I'm just really proud of how TACIR has worked on this. And my thought was, when it came up, and I was talking to Senator Watson, if we didn't have TACIR, this would never go anywhere, because there's no one who will bite into this and chew it up. And so just to the staff and all that worked on it, thank you very much. And it's a step, and that's all we need to get the ball rolling. Eventually we'll get there. So thank you.
Other comments or questions? Okay, hearing none, thank you very much.
Thank you.
We will move to tab 8, which is discussion of Public Chapter 795. We have Mr. Tyler Carpenter with us. Good morning.
Good morning. Thank you, Mr. Chairman, members of the Commission. My name is Tyler Carpenter, and today I'll be presenting the draft report on food deserts for your review and comment. The report was prepared in response to Public Chapter 795, Acts of 2018, which directed the Commission to study the benefits and costs of creating a special reserve fund in the state treasury for the sole use of funding grants and loans to encourage the financing and development of supermarkets, grocery stores, and farmers markets in food deserts, whose residents tend to have a less nutritious diet and poorer health outcomes than those living in other communities. A copy of the act can be found under Appendix A. In Tennessee, 21% of the state's population lives in areas considered food deserts. That's 15% in urban food deserts and 6% in rural food deserts, under the federal definition used in the report. While not always limited to food deserts, a variety of policy alternatives have been implemented in states and communities around the U.S. to both improve access to and encourage the consumption of healthy food, including improving transportation to and from healthy food retailers, bringing the food to the customer through mobile markets or food delivery, providing vouchers for fruits and vegetables, emphasizing education to encourage healthy eating, and offering grants to give residents healthier options for food and exercise. Since 2004, only 12 states have passed legislation creating healthy food financing programs. 10 of these states have appropriated their own funds to finance the development of food retailers in food deserts. 8 of the 12 states have directed state agencies to award and distribute grants, loans, or both. The other 4 states chose private entities known as Community Development Financial Institutions, or CDFIs, to award and distribute the grants and loans. On page 16, you can find a table listing the 12 states that have established food desert relief programs through state legislation. And on page 20, you will find the funding amount provided for these programs by each of the 12 states.
Mr. Chairman, we're missing that page. So just so you know, we don't have a 16 in the book. It goes from, or at least I don't, goes from 15 to 17, so. Yeah, I say that evidently the way heads are nodding, that's true across the, all right, thank you.
The primary barrier to opening grocery stores in many food deserts is that the expected revenues are not great enough relative to costs. To offset the startup or renovation costs for grocery stores and similar food deserts located in similar food retailers located in food deserts, governments and private entities have offered grants, loans, or other incentives. On page 7, there's a list of resources available to help improve access to healthy food. Also in appendixes B and C, you will find a list of recipients of the Healthy Food Financing Initiative grants available through the federal government. The grants and loans proposed in Public Chapter 795, Acts of 2018, would have been funded by a percentage of the revenue generated by the existing sales tax on food collected from the sale of sugar-sweetened beverages, which was estimated to generate approximately $26,000 per year. As Dr. Jackie Innerall explained at our May 2018 commission meeting, research has not consistently demonstrated that simply opening new or expanding existing grocery stores results in measurable improvements in diet and health, or reduces the actual cost of obtaining healthy foods for residents in food deserts. Without an emphasis on education and community outreach, just being closer to nutritious food may be less likely to lead to citizens purchasing, properly preparing, and consuming it. The draft report recommends that given the cost of opening and renovating grocery stores or other similar food retailers and the complex relationship between its improved access to healthy food sources and measurable improvements in diet and health, state efforts should focus on leveraging the variety of public and private resources that are already available to assist communities in crafting solutions tailored to local needs. A state program for encouraging the development of grocery stores and other food retailers in food deserts may not be necessary, but if Tennessee were to adopt such a program, The state should structure the program as a public-private partnership with one or more CDFIs or similar entities to take advantage of existing federal programs and to maximize private investment, and should incorporate consumer education and outreach into the program. And with that, I'd be happy to take any questions. And if I need to go over the other states, I can do that as well.
Yes. Yes, Representative.
Thank you, Mr. Chairman. And this is maybe more of a procedural question than an actual question about the report. I don't think we have the complete report. I know I have some pages missing, and I don't know if it's appropriate, Mr. Chairman, to pause until we get the report, or because I was listening, but I'd like to read it also.
I'll defer to.
So, yeah, apparently it looks like there was a copier after about page 11. Even pages are missing in the report. What we could do, and staff is getting new copies for the commission right now. What we could do is we could go ahead and hold questions until after the discussion on the next tab, and then come back once you have that in front of you and see if and cover the main points again and see if there are any questions.
Okay, without objection, we'll do that. We'll move on to the next one. Then when we get the information, we'll come back in case there's any questions.
All right,
Okay?
thank you.
Thank you. Okay, we will now move on to tab 9, and we have cord cutting and local government revenue.
Good morning.
Good morning.
Good morning. Thank you, Chairman. Thank you, Commission. You will find the memo for this update behind tab 9 in your docket books. So at the January 26, 2018 Commission meeting, then Chairman Mark Norris requested a study of the effects of cord cutting on the market for cable television services and local government revenues in Tennessee. Cord cutting in this context commonly refers to the practice of canceling or foregoing a traditional cable or satellite television subscription, sometimes, though not always, in favor of subscribing to video entertainment options provided over the internet. It is among a number of issues affecting the broader market for television and video entertainment services, as the options available to consumers and the methods for delivering content to them continue to evolve. This study examines factors affecting television and video entertainment services in Tennessee, whether changes in this market are affecting local government revenues, and whether any changes are warranted in the state's tax laws, cable franchising laws, or related laws governing processes for deploying infrastructure in public rights-of-way. To help determine what changes, if any, are already occurring in local government revenue related to changes in the market for television and other video entertainment services, Commission staff, with the assistance from the Tennessee Municipal League and the Tennessee County Services Association, have sent online surveys to all local governments in Tennessee requesting, among other information, the amount of revenue they have received in television franchise fees, cable television franchise fees, in the last 5 fiscal years. Looking ahead to the next Commission meeting, staff plan to invite a number of stakeholders, including providers, local government representatives, and other affected entities to participate in panel discussions for the Commission. Today's update provides background information both on the taxation of cable television, satellite television, and their internet-based alternatives, and on the laws governing cable television franchises in Tennessee. We will hear from Sherry Hathaway, Director of the Tax Policy and Development Office for the Tennessee Department of Revenue, Jerry Kettles, Director of Economic Analysis for the Tennessee Public Utility Commission, and John Hutton, the Telecom and Utilities Consultant for the Tennessee Public Utilities Commission. And I'd like to thank them for the help that they've provided staff so far. They've been very gracious with their time with us. So thank you, and if there are no questions for me, I will defer to the panel.
Any questions before we recognize the panel? Okay, thank you. We'll ask the panel to come forward then. thank you all for being with us today. We appreciate you being with us and appreciate the assistance you are providing and going to continue to provide concerning this issue. So I guess we'll start with you, Ms. Hathaway, and move on down.
Thank you, Commissioner. I've been asked to talk a little bit about the situation with regard to the tax laws for these three different areas, and give you a little bit of a brief history about how we got to where we are today. So first, I'd like to talk about cable and wireless cable services in the state of Tennessee. We first began taxing cable services June 1st, 1984. We taxed them as an amusement service. 1984 was when we first imposed tax on amusements. We taxed cable services in excess of the basic or lowest charge. We adopted a rule that kind of defined basic television services. This rule becomes problematic because it's based on a tax exemption that is determined based on the content carried by a channel. It was later, in later years, determined by the department to probably be unconstitutional. But at the time, this was how we approached taxation, so that premium and pay-per-view channels were basically what we were taxing. They were subject to state and local tax. So we progressed through to the 1990s, and in 1996, I'm going to mention this several times, but in 1996, the federal government passed the Federal Telecommunications Act, which was very, very significant in reducing some regulations and encouraging competition between different types of service providers. The department had issues with, as I mentioned before, the basic television service exemption. And so in 1999, the legislature passed legislation to basically revamp what we were doing with regard to the taxation of paid television services. We adopted a definition of video programming services, and we identified the three carriers or providers of this type of service as the cable providers, those authorized under Title 7, Chapter 59, the wireless cable, which is there's always been a very, very small market of this. They provide a cable service via an antenna in areas where it's very difficult or not cost effective to put out coaxial cable. At the time we did this, I think there were probably 3 providers in the state. There may be 1 left now. Broadband television programming. So because of the Federal Telecommunications Act and the increase in competition, we have telephone companies that are providing cable services now, or at this time, and they are, so we've included them so that these people are generally the ones that are paying those franchise fees, and they're collecting tax, and they have, they're all being taxed kind of the same. The video programming services, specifically, the law specifically provides that it does not include products transferred electronically or direct home satellite. So again, we're still keeping with this 3 different kind of markets or 3 different kinds of providers. The tax scheme that was adopted for video programming services is a bit difficult. The first $15 is exempt from state tax. That $15 represents the replacement for basic television service. At the time, we did a study to determine what the cost was at that time. I think it was $12.50. And when the legislature passed the legislation, it became $15. $15 to $27.50 is subject to 8 1/4 state tax, no local. The amount from $0 to $27.50 is subject to local tax, or is exempt from local tax, and then everything above 2750 is subject to the regular state and local taxes. Satellite television services was actually first taxed in the state June 9th, 1994, when the Department of Revenue issued a ruling determining that satellite television services were subject to tax as interstate telecommunications, which was under old law, not our current telecom laws. Satellite television services were determined to not be exempt as television services broadcast for public consumption because they required a fee to be paid and they required special equipment to be accessed, the satellite dishes. We made assessments, the department made assessments, we were sued, litigation, and I mentioned the case here because it's kind of unusual. We lost the case, the Court of Appeals, and on the very same day that we got that decision, we changed the laws to specifically impose tax on direct-to-home satellite services. They are subject to an 8.25% state rate. The $15 basic television exemption that is in existence now for video programming does not apply. The terminology and the prohibition on local tax comes from the Federal Telecommunications Act of 1996. In 2009, the department and the state of Tennessee, we adopted the digital definitions, digital product definitions that had been worked on by the Streamlined and was a part of the Streamlined Sales and Use Tax Agreement. Specified digital products, and it specifically includes electronically transferred digital audio-visual works, which I think is what we're really talking about here today. Electronically transferred does include downloading or streaming online without download. Specified digital products do not include video programming services or direct-to-home. So this is where we have the final third category of these video television services. Digital audio-visual work specifically is defined as images when shown in succession impart an impression of motion. Motion pictures, these are examples, music videos, news programs, entertainment programs, and live events. So today, those packages that someone can get online are in fact specified digital audio works, specified digital products, and subject to tax in Tennessee. Tennessee imposed tax on the specified digital products to include products whether they're received for permanent use, whether that you get them for 24 hours and then you don't have access anymore, or whether you get them as long as you continue to pay a subscription fee. So we're basically taxing all of them. Tax applies to the specified digital products to purchasers and subscribers with Tennessee residential or business addresses. The specified digital products are subject to a 7% state rate and a standard 2.5% local rate, and the local monies are distributed to the local governments based on a formula. Are there any questions?
Okay, we'll move to the next presenter.
economic analysis at the Tennessee Public Utility Commission. I'm joined by John Hutton, who serves as a telecommunications and utility consultant with the agency after a long career in the telecommunications industry. John and I have been involved in the agency's implementation and administration of the Competitive Cable and Video Act since its passage in 2008. Also, other members of the commission staff that have equally long experience with the Competitive Cable Act and expertise in specific subject matters that could arise at today's hearing are present and available. We've been asked to discuss the history of cable television oversight and the roles the commission currently plays in the franchising process. The first cable television companies appeared in the late 1940s in communities that had poor broadcast reception. The early cable companies would place an antenna somewhere that had good reception and run cable to homes that had poor reception. Over 60 years later, our cable and video companies provide access to hundreds of channels of programming, on-demand content, home security services, telephone service, and often broadband internet service. Oversight of cable television historically has been at the local level using franchise agreements. Local franchise agreements establish franchise fees, access to right-of-ways, and provision of public educational and governmental programming. At the federal level, the Federal Communications Commission has issued several rulings implementing federal legislative efforts. Generally, these rulings have set limitations on the franchising process. In Tennessee, prior to the passage of the Competitive Cable and Video Services Act in 2008, cable service was regulated by local governments through local franchise agreements. Prior to the mid-2000s, telephone companies did not have the technological ability to provide a service similar to that provided by cable television operations. To enter the market prior to passage of the Competitive Cable Act, a company would have to negotiate a franchise agreement with each political subdivision where it wanted to provide service. The Competitive Cable Act provided an alternative to the local franchising process by allowing a state agency to grant franchises for any location in the state. Under the Competitive Cable Act, providers can still choose to negotiate a local franchise agreement, but they can also choose to franchise through the state franchisor, the Tennessee Public Utility Commission. Tennessee is not alone in creating a process for video franchises to be issued by a state agency. Texas was the first state in 2005. The National Conference of State Legislatures reported that as of November 2014, half of the states had a state-level process for issuing cable and video franchises. The Competitive Cable Act clearly defines the roles of the Commission. The Competitive Cable Act was designed to streamline entry into the cable and video market. As such, and I quote from Tennessee Code Annotated 759-302, "It is the intent of this part to confer a limited role in the Tennessee Public Utility Commission, referred to in this part as the department, which will be ministerial and narrowly construed, except to the extent otherwise specifically provided in this part, and no rulemaking authority is provided as that." In that, the TPUC has a very limited yet specific role to perform under the Cable Act. While the role of the Commission is limited by statute, the functions we perform are essential to the well-functioning marketplace. There are numerous acts that the Competitive Cable Act requires of the agency. I'll focus on the two that are most important for facilitating the statutory intent of creating a, quote, fair franchising process for cable and video services. Those key functions are the review, granting, and monitoring of state-issued certificates of franchise authority and serving as a forum to resolve disputes that may arise between parties operating under the Competitive Cable Act. Concerning the review, grant, and monitor of state-issued certificates of franchise authority, to grant a franchise, the company must demonstrate that it has the technical, financial, and managerial ability to provide service. By statute, incumbent cable providers and large telecommunications companies are deemed to have sufficient technical, managerial, and financial ability. For other companies that seek franchise, the agency reviews documentation provided by the companies and makes a determination. Since the passage of the Cable Act, the agency has issued 23 franchises, all within statutorily required timelines. One franchise is currently pending. The Commission also serves as a forum to resolve disputes under the Competitive Cable Act. The agency has extensive experience in resolving disputes related to utility service. As such, resolving utility disputes is one of the Commission's core competencies. Disputes under the Cable Act that can be considered by the Commission could arise from a variety of circumstances. For example, the Commission can resolve disputes related to franchise fees, the provision of so-called PEG channels, consumer complaints, and disputes related to the build-out of telecommunications or cable facilities. Each type of dispute has statutorily required procedures. One final point. We were asked by TACIR staff to address the distinction between franchise fees and fees to access right-of-ways. By statute, franchise fees are based upon gross revenues of the provider. Fees to access right-of-ways are distinct from franchise fees. This can be seen in TCA 759-306. That makes the distinction clear by indicating that a governmental entity cannot levy additional fees other than one that is intended to provide compensation for the use of public right-of-ways within its municipal or county authority. Thank you for the opportunity to present, and we'd welcome any questions.
Mr. Chairman, give me that statute again on the access fee, please. 759 something.
306.
306.
The last one.
And also a question about, and I apologize, I've got a really good finance guy, Dick Phoebus, and because of that, he normally is in my ear answering these questions. But the amount of money we receive from state contracts, how is that distributed? If a company is located in our community and chooses to go through the state and they're doing business in our community, how are we getting, or are we getting anything at the local level out of those?
The franchise fees are statutorial. The law doesn't really tell you how to do that, but in most cases that I'm aware of, the provider, and there may be more than one provider in a particular municipality, is required to contact somebody at the city or the county and work out a payment schedule. Then, yeah, I think the law actually calls for quarterly payments. You know, you'd have to meet, the provider would, to make sure that you have the right address at the city hall or wherever they're going to pay it, and then talk to somebody by phone, because it's all based on revenue. So most of the cities that I'm aware of actually find out what that revenue is and then prepare an invoice or a bill. And then it follows the same thing that the process that anybody, most cities follow.
Mr. Chairman, in regard to that, could we get the utility district folks and our folks to give us a chart of those state contracts and who they're with, so that we could just take a look at that and maybe talk to some of these communities, be sure they're aware of this and that they're aware of how to go about getting their fair share of those revenues, please?
I'll refer to Cliff on that to answer that question.
I'm sorry, could you say that again, please, Mayor?
Yeah, so they said, I forgot the exact number of state contracts. There weren't a lot. Of course, we have agreements with AT&T for the UVerse, and we have agreements with Comcast Xfinity, direct contracts. But he mentioned some number of companies that had done it at the state rather than the local franchise agreement. So I'm asking for some kind of a list of those companies that have done state contracts, and just maybe the staff then could do a polling, just some kind of a general polling across the state to make sure that cities are aware that those are there and who's using them and whether they're getting any revenue from that or not.
Well, it's certainly early enough in this project to work something like that into it. I think that's something the staff we can either do, or if we can't do it, we'll get back to you and let you know why we can't do it.
Okay, well, I think perhaps if they work with the utility district, we'll have a good number of knowledge about that, and it would seem doable. But if it's not, you can let
I
me
believe it
know.
would be,
Yeah.
yes, Mayor.
All right, thank you.
Mayor Greer.
This question would be for Ms. Hathaway. Also, could you share with us, it says local taxes are distributed to locals based on a formula. Could you share with us what that formula is at the state level?
I believe it's probably the formula is based 50% on population and of the jurisdictions and 50% based on collections.
Okay,
Okay?
okay. If we could make that a part, Mr. Chairman, part of this report, the actual formula and how it works.
Okay, I think Cliff's shaking his head. I think we can do that. Mayor?
One of the challenges we've had since state franchising came in our municipality is disparate access to our citizens and residents to cable and internet services. When they had to negotiate with us, we could include in that, we want you to treat all of our residents the same and have access to everybody as part of the franchise. Now there's a sense and complaint from some of our residents that the state franchise folks tend to cherry pick. They tend to decide, here's where the most profitable, easiest, most cost-effective areas within the municipality for us to provide cable and internet are, and it's not, and their response is it's not cost-effective for us to provide it to those areas that don't have it. Our residents don't understand why some of them have better cable internet access than others. They all live in the same municipality. So what leverage under current state franchising do we have to insist that those who get the state franchise and who are in the business of providing cable internet in our city do so to everyone so that we don't have disparate access between our citizens?
The statute has very clear requirements for the build-out, and given sort of the statutory constraints placed on us by the Cable Act, we can only hear an issue related to that under certain circumstances, and those are set out under the statutory requirements for build-outs.
We've heard lots of testimony, we've heard lots of data and very convincing information that broadband is a very important tool for the success of our citizens and our communities. We don't have disparate issues on electricity and water and other things that people would argue are important tools for success. So what can be done so that we treat all of our residents, at least within our cities? I understand counties, you may have very rural areas and the state's looking at how we can deal with that. But what can we do so that we treat residents of the same city equally and the same when it comes to access to what many now say broadband, for example, is a very essential tool for success?
I actually understand what you're asking. I think that the digital products that are available online or that are just starting to be available online, the television packages, I think the state, you just recently last year did the broadband credit to increase internet access and to make internet access available in areas where it's not available. I think the trending is that the fact that there are these three different service providers is going to cause increased competition in a way and services in a way that if you can't get it with cable, you're going to be able to get it online if you've got internet access.
But my experience has been that to have access to these, whether it's Hulu, YouTube, DirecTV online, Sling, which the services people use to cut the cord, so to speak, you've got to have broadband internet access. And in my community, broadband and cable tend to go, they run together. If we have high speed, we have the cable, we also have the broadband. If we don't have the cable, then people are back to using the older technologies of internet access, for which the new cord cutting technologies are simply not. You can get them, but the lag and all is such that it's a very discouraging process if you try to use them, which means you're back to, you don't really have them. And so that's the concern, is that the state has eliminated my leverage, because if they had to come to my government to get a franchise, I can say, I can include in that access. I have zero say in that now. And I guess what would be the challenge if the state of Tennessee were to say, as part of getting a franchise to serve a municipality, you have to provide service to the entire municipality?
As of now, in statute, the build-out requirements are they must reach a certain percentage of the population within a certain period of time.
I understand that, but if you're going to give them, if you're taking away our ability to negotiate access, and what would prevent the state from saying, if you're going to provide cable, you're going to provide it to a municipality, whether it's a municipality of 500 people or 50,000 people. If you want to provide to one citizen in that municipality, you got to provide to all of them, just like we provide water and just like we provide electricity. That's my question, because it seems to me that would be a simple solution to the disparate access.
I think I would say that there are utilities that do provide cable services today, and I think that the laws allow for them to do that if they want to do it, just like they can do broadband. We did the broadband credit last year, and I think that was also about getting better internet, or some internet even, in the rural areas where there had been cherry picking and they didn't have good service or any service. I think that if a utility, electric or a telephone co-op, wants to provide cable, I think that there are laws that will allow them to do that.
But the problem we have is they don't want to, they want to pick and choose within my municipality, for example. They want to pick and choose who they provide to. And they're picking, as I understand it, they're a for-profit business. They have to answer to shareholders and everybody else. They're trying to do it in the most profitable way they can, but that's resulting in, disparate access. And that's a hard question when somebody calls you up and says, my neighbor 500 yards away has this, why don't I have it? I've got electricity, I've got water, why can't I have the same cable and internet access as the other one? And, which is why my suggestion was, I'm struggling to understand why that would be. I can see why the providers wouldn't like it, but as a state saying we want to enhance access, we want to enhance broadband, if you give it to one municipality, you got to give it to all. I'm struggling to understand why that would be a hardship. I can understand it may cost them more money, but I'm not sure why that would be a hardship on the state of Tennessee or its citizens to require that of the statewide franchising. Okay.
Well, I personally take a lot of those calls that maybe before or after they talk to you. And from my point of view, of course, we're not supposed to be taking complaints about such things, but if a taxpayer calls and until they order me to not talk to them, I'm going to continue to do it. And what I usually do is listen to their problem, where they live. I try to find them on Google Map. try to determine who it is that they may have talked to or that may be available to serve them, and try to leave them with some hope some way. If I know that a provider has gotten some Connect America Fund money from the FCC, then that's some hope. That company may provide some service to them. But in the end, from my experience, all of the providers are guilty of what you just described. And it has to be economics. There's a lot of people live, and they admit to me, they live in a place that's very hard to serve. But in summary, it would require a change of law.
Okay. Thank you guys for answering my questions. Thank you, Mr.
Chairman?
Thank you, Chairman, and I was just going to agree with my colleague, the Mayor of Louisville, and say you're absolutely accurate. And to answer the question of what would prevent this state from absolutely nothing, except for the fact that it would have to pass through the Tennessee General Assembly. And in regards to my equal access broadband bill, the 23 lobbyists that were hired to kill the bill in committee prevent the state from moving forward. So you're exactly right. I was quoted in the paper as saying, I can look out my back porch and see White Oak Mountain in my colleague Judge Carter's district, Representative Carter's district, and they have gig service. I can see gig service from my house, but I can't get it. And there is absolutely nothing preventing the state from doing it. It must pass through the legislature, and that is the hurdle that it cannot pass through. 50% of it last year was passed. We got the rural broadband access to counties, but municipalities like yours and mine are exempt from that bill. To be continued.
Okay, Representative Carter.
I was quite shocked in a meeting with a service provider last year when we were trying to pass that bill, and we couldn't walk through the halls for the people opposed to it, and that's what happened to it. In 1980 or 81, I'm fresh out of law school. I'm one of the Hamilton County assistant attorneys. I'm sitting in a room negotiating the contract with a group called Chattanooga Cable TV. The number one requirement was you will get this franchise if you provide every home in Hamilton County service. Your bid must provide service to every home. If you do not, your bid is rejected. We had no trouble doing that. A few years later, I start getting calls, why we don't have service? And I said, well, I don't know. The contract requires it. Guess what? It transferred to Nashville, and there were so many loopholes, you couldn't deal with it. I was told by people who know that my district and the one in Bradley County that touches mine are the two least served areas in Tennessee. That Byrdstown, Tennessee is 100 times faster than my district. I don't know if you've ever been to Byrdstown. It is a beautiful place. I love it. But you wouldn't say it's an urban area. So until we return this to the locals who have the right to do this to protect their citizens, it's never going to work. It's never going to work. The juvenile court clerk in my county today has dial-up service. Dial-up service. The cost of providing high-speed internet, he has a letter, $79,800 and something dollars. We were promised in this rural broadband bill that it would occur. It hasn't. It still hasn't. It's not going to. We're allowing people to cherry pick. We're creating two Tennessees, the haves and the have-nots, and that is extraordinarily offensive to me. Whether it's my district or my friend from Memphis district, it's not right, and I resent it. Thank you.
Okay, yes, Mayor.
Yeah, I would just have a question. Thank you, Mr. Chairman, for Ms. Hathaway. Do you have auditors that review? You said that the statute requires it, but do we have, it seems that we have no punitive measures for those that are not following through with their contract. Do you have auditors that follow that?
We don't really audit the franchise fees. We're auditing the sales tax, the business tax, and the franchise and excise tax. And we do have auditors that do those audits, yes.
So there's no one following up on the state franchise agreement to be sure that it in fact is followed through with?
There is a very complicated process for the audit and review of franchise fees that's set forth in the statute. It involves basically a bilateral attempt between the municipality and the provider to resolve the dispute of the fee, the option to involve the comptroller of the treasury, and then ultimately either a case before a court of competent jurisdiction or a case before the utility commission.
But that still, if it's okay, Mr. Chairman, that still is talking about the fees that are paid and whether they're all being paid or not. That's not dealing with those who are not following the state contract that requires them to give it to everybody. You're only auditing the fees that they are supposed to be paying and how much they're paying. You're not auditing availability, which the state statute requires, as I'm hearing. So if I'm wrong, please correct me.
The state statute does not require universal availability. It only requires the build out to certain areas in certain periods of time.
There it is.
Okay, Representative.
Thank you, Mr. Chairman, and to my colleagues on TACIR. I certainly hear your voices, and that's one of the things that even in a city like Nashville, that we oftentimes have conversations about equal access because there are pockets of Nashville because of income level of the communities where access was not as plentiful as it should be. And so I think as we continue to go down this path of talking about access and what I think nationally is being talked about with net neutrality, because it also deals with the speed of the internet to allow you to get these services, that we need to give careful consideration to how we are looking at services that are provided across our state in our rural areas, in our municipalities, and in large cities where, again, sometimes the social economic desperate areas don't get the same access. I do want to ask this question, though, as we talk about cord cutting and video programming. How do you track who is providing these services, these other video services?
Well, we don't track those at all. We know that there are certain agreements between municipalities, counties, and providers. They just have an option as far as the state law goes to, if the provider wants to opt into the state contract or the state certificate, then they're allowed to do that. But the municipality does not have the right. It's the provider. So there are many, we don't really know how many there are between municipalities and counties and some providers. We don't know. But if they're satisfied, if two parties are satisfied, then they don't have to opt into the state. So we don't know how many there are. They're about, statewide, Jerry mentioned, we have 23 and working on number 24, so.
Okay. Was your question to what John just answered and to over-the-top streaming providers?
Yes.
The numbers of those? None of those have sought a state-issued certificate of franchise authority.
And so for me, this is similar to the conversation we've had about internet sales tax. Some companies opt in to pay. We have no way of knowing unless someone voluntarily comes in. Is that correct?
My memory of the statute is the definition of a video service excludes programming that's delivered over the public internet.
Okay.
So they would, if they're not covered under as providing video service, then they would not need a certificate of franchise, so we wouldn't know.
Right. So there may be multiple companies out there providing the service, and we have no way of knowing who is providing service and who is being denied service also, correct?
From a over-the-top streaming provider or from a provider that has sought a state-issued certificate of franchise authority?
Over the top.
I frankly couldn't give you a complete list of the people who are operating in that market space, and it's a very fluid space.
Sure.
With lots of competitive entry.
Okay.
So we wouldn't know. Generally, you would need a broadband connection to receive that service, but we can't tell you who they are or where an over-the-top provider is providing service.
And I guess that was part of the genesis of this report, was to try to figure out how much was being lost or not collected by cord cutting services that are provided, correct? Video streaming and that sort of thing.
Well,
I'm trying to read here. I guess that's what I read. Help me understand that.
So, someone who is making sales online, digital audio visual works, we talked about the specified digital products. Those taxpayers, if they have nexus in the state, are required to register and collect sales tax on their sales. I'm not aware that there's any requirement for a franchise fee of any kind. They're not really, I don't think they're defined as cable providers. They do have, I mean, I've done some research working with Dr. Owen. They are collecting tax, some of them. I'm assuming that's because they have Nexus. There may be some that aren't collecting tax because they don't have Nexus. They don't have any infrastructure here. They don't have any equipment here. They don't have offices here. You literally sign up for them via the internet, and they're making sales over the internet to residents in the state. So some may not be registered if they don't have Nexus.
Sure.
And they do have a different tax structure in that they have their fees are subject to a 7% state rate and a standard 2.5% local rate, which is distributed based on a formula, the 2.5%.
Okay. All right. Thank you for your answers.
I'm going to recognize our executive director to sort of give us some context for what we're talking about and how we may address some of the issues that have been raised here today.
Thank you, Chairman. So we're right now working on 3 very related studies. This one on cord cutting that was requested by Leader Norris earlier this year, one on 5G or small cell technology and the effects on the industry of those. And then, of course, we have an update on our broadband access and adoption study, which that update is due in 2021. So some of the questions we have today are germane to this study and cord cutting and the effects on, particularly on local revenue. And that's what this study is. We've committed to having a draft at our May meeting, May 2019 meeting, and then a final study by the end of 2019. The question that Mayor Bickers brought up was an excellent question and something obviously the Commission is interested in. And what I would recommend is that we work that question into our broadband access and adoption update and address it as part of that. Now, that study is not due to 2021, but as we've done in the past, we will be providing interim updates on our research on that topic as we go forward. And so we could return to that issue after we've had a chance to look at it and include it as part of that access and adoption update.
Cliff, I appreciate that, but in some ways, I view the cord cutting and the access as very related. as I understand the testimony today, if someone is acquiring their internet and their cable TV through traditional cable, then they're paying a tax. If instead they choose to cut that cord and only go with, say, Sling or DirecTV Online or one of those services that charges you a flat fee a month, I guess the same for people in Tennessee as California, they're not paying any tax.
I don't think that's correct. I do think some of them are collecting our Tennessee sales tax on the sales of services to Tennessee residents. I don't know that they all are.
Okay.
And whether or not they all are is dependent in part on whether they have nexus.
Okay. And I guess I see disparate access equaling disparate. Our citizens ought to have fairness and all be paying relatively the same thing for the same services. You shouldn't have to pay more because you don't have broadband access than somebody who has broadband access. So from that respect, I see the two as somewhat related. And how we handle that, maybe we put it all off to 2021, but I understand you've got 3 separate studies, but there are ways that I think cord cutting and access are connected, and particularly when it comes to, fairness of our taxpayers.
And I wouldn't disagree with that. I think there probably is going to be some overlap here, and we will take a closer look at the research plan for this and see what portions of this need to be included in that draft report for May of this part of it. But I'm sure we'll see it again when we get to the access and adoption update also.
Okay, I don't think we heard Mr. Hutton's presentation yet. We've.
I was there just to answer questions.
Oh, okay. Well. Come on, John. Then, do we have further questions? Okay, hearing none, I'll thank the panel. Appreciate you all being here today, and been very informative for us. Thank you. Okay, we are going to go back to the review of Public Chapter 795 now, and I think you have fresh copies of that includes all the pages. So we'll recognize again Mr. Carpenter to continue his discussion.
Am I on now? Yes. Okay, excellent. So I'm going to briefly go back over some of the things that I had said before that are on those pages that were not available. Then I'll restate the recommendations, and then we can discuss any questions that you may have. So the first thing would be the tables that were on pages 16 and 20. So since 2004, there have been 12 states that have passed legislation creating healthy food financing programs. 10 of these states have appropriated their own funds to finance the development of food retailers and food deserts. 8 of the 12 states directed state agencies to award and distribute grants, loans, or both. And the other 4 states chose private entities known as Community Development Financial Institutions, or CDFIs, to award and distribute grants and loans. And as I had said earlier, the breakdown is on page 16 for the states that have established a program through state legislation, and then on page 20, you'll find funding amounts. And you will see 13 states on page 20, and that's because there are some states that did not create a program but gave money to a CDFI to help support that program. The next thing I'm going to restate is the barriers. So the primary barriers to opening grocery stores in many food deserts is that expected revenues are not great enough relative to costs. To offset startup and renovation costs for grocery stores or similar food retailers located in food deserts, governments and private entities have offered grants, loans, and other incentives, and you can find those on page 7. We've created a table listing all of the incentives that are already available. And in appendixes B and C, you'll find the federal grants through the Healthy Food Financing Initiative that are available as well. And the study asked us to look at the way that this would be funded, and they would have been funded through a percentage of revenue generated by the existing sales tax on food collected from the sale of sugar-sweetened beverages, which was estimated to generate approximately $26,000. And lastly, to restate the recommendations, the draft report recommends that given the costs of opening and renovating grocery stores and other similar food retailers and the complex relationship between improved access to healthy food sources and measurable improvements in diet and health, state efforts should focus on leveraging the variety of public and private resources that are already available to assist communities in crafting solutions tailored to local needs. A state program for encouraging the development of grocery stores and other food retailers in food deserts may not be necessary, but if Tennessee were to adopt such a program, the state should structure the program as a public-private partnership with one or more CDFIs or similar entities to take advantage of existing federal programs and to maximize private investment, and should incorporate consumer education and outreach into the program. And with that, I'd be happy to answer any questions that you may have.
Yes, ma'am.
So on page 12, it talks about the barriers to healthy food retailers. And it says a representative of the Tennessee Grocery and Convenience Store Association. And then later it said, he said that the national chain would spend about $5 million to open a location. Is there any confirmation of that? I mean, that's pretty generalized, and somebody just said it. You know, do we have any facts to go with that?
So that was in an interview with the president of the Tennessee Grocers and Convenience Store Association. We asked for a range of how much it costs to open a grocery store. And so he gave us a small dollar amount, and he said some of the larger, like the Kroger's, the Whole Foods, that because they're much larger and much bigger operation, that they sometimes go up to $5 million. That was from that interview. I don't have any additional for the $5 million number. I have some for the $740,000 up to 11 or 1.1 million.
So I guess, Mr. Chairman and Cliff, as we look at this, helping us boil this down to real quantifiable numbers that are verifiable, quantifiable and verifiable numbers, so that either the local governments or the state government can determine whether or not a CDFI or some other legislation would be beneficial, or is it something we do by grants locally. But until we have I realize there's some other charts, but there's a lot of charts, but they're all provided by agencies of the federal government, which I'm not sure I would totally, you know, what is it, Reagan said, trust but verify. So that's what I'm looking for is, out of staff, are these numbers verifiable? Are they justified, you know, verified? So I would just leave it at that, Mr. Chairman. Thank you.
Yes, Mr. Chairman. In addition to that, I'd like to add, I think you made a very valid statement earlier that we can provide access, but we need to educate the individuals. And I think that's something that has been left out of a lot of programs, that we need to provide that education, just like was mentioned in the land study, to involve CTAS, MTAS. Then what we might look for is, we don't have, what do they call them, the home extension agencies. Those aren't, you know, big in the community anymore. We have implemented in Morristown with a real drive at our farmers market, the SNAP program, but that has been an education process to the individuals who frequent the market by our downtown association that helps operate the farmers market. So I think if you would also look into those ways, then that we could provide the information that is needed.
Okay, further questions, comments? Yes, Representative Love.
Thank you, Mr. Chairman. Let me thank the staff of TACIR for your deep dive into this, and I think that it helps us really get a picture of what we're dealing with in the state of Tennessee. Because prior to this, I don't think we knew how many of our residents were living in food deserts. So to say 21% of our population, that is a good amount of people who don't have access to fresh fruits and vegetables, and you compound it with the education piece. So we're talking about how do we provide access to that fresh fruit and vegetable market, and additionally provide access to education about the benefits of eating healthy. And I'm going to suggest that we look at our two land grants, the University of Tennessee at Knoxville and Tennessee State University, with their cooperative extension programs, because they cover all 95 counties, to go into these areas and help educate our population about the benefits of healthy eating, the benefits of knowing how to budget around your dollars and to get access to fresh fruits and vegetables. So I think there's an opportunity to, in this next session, look at how we might fund some type of grant program, since we know that there's a need out there, and we know that this is all going to continue to compound our health issues. If our communities are not eating fresh fruits and vegetables, it's going to lead to higher rates of obesity, higher issues of heart attack disease and stroke, diabetes. And so for me, when we talk about our children and in our schools, it's also important to talk about giving them access to fresh fruits and vegetables and learning about the importance of a good diet and exercise. So I think that many of the comments that have been made are very helpful, because we are still pushing toward this effort of how to reduce the number of food deserts in our state. And I'll look forward to other input from members who might have ideas about what is working in your area and what is needed to attack this issue. Thank you, Mr. Chairman.
Mr.
Yes,
Chairman,
thank you. Yes.
he reminded me of something. First of all, I'd just say, even with our children and also for us as adults, we eat what we're familiar with. And that's why I still like good fried bologna sandwich and things that my doctor wouldn't like for me to eat. But, I'm familiar with those from, my childhood. So the other thing, though, is in public chapter over on page 2, public chapter 795, it talks about what have been administrated by the ECD. I wonder if this moves forward in the legislature, if that might be better if it were either ag or jointly between ag and ECD. Ag has the most expertise in this area and the most to gain or lose. So I would just put that out there for your consideration as staff as you look at this, whether or not we're looking in the wrong agency for the help and support we need. Thank you.
Okay, further questions? Hearing none, thank you very much. We appreciate that.
Thank you.
Okay, we're down to other business, and we have, we need to set the next meeting, and let me say before we do, we have 2 dates there, but now Judge Norris wants to be here at the next meeting, and he can't be here on the 24th and 25th. He only can attend on the 31st and February the 1st. My question is to the commission, do those dates work, the January 31st and February 1st?
24th and 25th doesn't work for me.
Yeah.
We have an ATBG meeting.
Oh, okay.
That works for us, too.
Okay, sounds to me like we've got a consensus of the next meeting will be January 31st and February 1st. Okay, and do we need to set the spring meeting, or we just wait till January? Okay, is there further business to come before the commission? Yes.
If I may, since it's our last meeting, I would like to take this opportunity to thank our TACIR staff for the work that they do and going the extra mile in all that you do to put the reports together. There's a lot of legwork that we are not truly aware of, but we see the results, but there are numbers of hours behind that and the expertise, and just want to thank you very much, and thank you, Mr. Director.
Okay, thank you. Other comments? Yes, Mayor.
Thank you, Chairman, and on behalf of my predecessor, Mayor Tom Rowland, who is watching live online, believe it or not, he's actually texting me, and he truly enjoyed his tenure here of 23 years on TACIR, and is watching eagerly to see the progression, and I just he wanted me to make sure that everyone knew he misses all of you, sends his greetings from Cleveland as Mayor Emeritus, and I'm very thankful to be here as well. Thank you.
We're glad to have you and appreciate his service for those 23 years. He did a great job on this commission. Further comments? Hearing none, do I have a motion to adjourn? So moved. Do we have a second?
Second.
All in favor of adjourning, please rise. We're adjourned.